was wrong. I'll tell you this. You are ready to keep your mouth shut, or else. Because if you talk, do I have to draw pictures for you to know what other people are going to think about you?
Despite this new openness, sexual abuse is still portrayed, as it has been for the last 100 years, as a crime that happens outside the family. The reality is that most cases of molestation occur between family members, and in the 1970s, when it first surfaced, the idea of sexual abuse of children was a shocking and painful revelation.
The discovery of child sexual abuse was particularly dramatic because suddenly we were talking about middle-class and upper-middle-class families. There were many in our communities who could attribute child abuse to lower-income families, minorities, particularly perverse, violent people. But when the cases of incest started coming in, suddenly you have a population of very successful professionals who are being brought into the Child Protective Services system, and that really knocked the wall down in terms of child abuse.
When the pediatricians first reopened the doors to child abuse, it led to a response that echoed the passion and ignorance of the early child savers. Protecting kids came first. Saving families was an afterthought. As a social worker during the late 1960s, Deanne Tilton removed many children from abusive homes.
There was an immediate response to rescue that child, get that child away from that person, put that child somewhere where the child will be safe, and never let that parent near the child again. There wasn't a differentiation between those cases involving real danger to children, where children could be removed permanently as soon as possible, and those cases where there was a real good chance for rehabilitating the family.
Child abuse hotline, can I help you?
They're just hungry, and they're...
With more concern for identifying abused children than rehabilitating families, new nationwide reporting laws required doctors, teachers, and social workers to report suspected cases of abuse. From now on, the family was open to public scrutiny. Hotlines were jammed with reports.
As part of our investigation, we always talk to the children that are verbal, alone and away from the parent.
The impact of recording laws passed in every state in the United States in the 1970s was in one part good, and that is it did an enormous amount to raise public consciousness, to start people talking and thinking about what is and isn't child abuse. But I actually have to worry whether the other part of that impact wasn't negative, because people sought mandatory reporting as a cheap solution. People thought, this won't cost us anything. This is a freebie. All you do is pay for a hotline. But what is the point of having mandatory reporting if you don't have the staff and the resources to do something about the complaints you get?
But we didn't and still don't have the resources to care for all the children who need help. Last year, there were 2.5 million reported cases of child abuse, an increase of nearly 90% since 1980. For the past 8 years, social workers in communities nationwide have struggled with overwhelming caseloads, some juggling up to 90 cases at once. Many children have been lost among the paperwork, sent from one foster home to another, forgotten. For some, this meant freedom from abuse. For others, it became a nightmare of re-abuse.
The main lesson of the 1960s and 70s was that removal of the children is not the end-all, be-all.
Pam Moore is an attorney for the Public Interest Law Office for Los Angeles County. She specializes in child protective law.
When our system re-victimized the children who had been abused by their parents, it could take a number of different forms. It might take the form of physical or sexual abuse by the foster parent. It might take the form of neglect by the system. That could be that I've had cases where the child has had 13 different social workers in 7 years, where they've lived in 15 different homes in 10 years. And the child in that case has no chance to bond with anybody, no opportunity to develop a family relationship.
Children were not the only ones who felt this official intrusion into family life. Many parents who were not guilty of child abuse felt paranoid about the possible accusations. A child with a bloody nose, scraped knee, or a change in behavior became suspect. Attorney Alan McMahon is a lobbyist for VOCAL, Victims of Child Abuse Legislation, a national organization that believes that many cases of reported child abuse are unfounded and that many parents have been unjustly accused.
The system now is taking children away from their families, destroying the family, sometimes permanently, traumatizing the children, losing their security. Children think that their parents are the most powerful people in the world, and they suddenly find that their parents can't protect them. They have no power at all.
In a replay of history that mirrored the accusations against the 19th century child savers, a backlash hit in the early 1980s. Along with VOCAL, conservative and religious groups such as Focus on the Family and the Coalition for Traditional Values spoke out for the rights of parents to discipline their children without government intervention. They also called for renewed commitment to family sanctity.
Those who are in the business, if you will, of protecting children have become overzealous. We've had psychologists reporting someone who said he was afraid he might hit his child. This was reported as abuse. A person is looking for help to keep him from doing it. He has not abused his child. But that report is made. So clearly there's a lot of overzealousness. There's a lot of maliciousness.
There seems to be a very clear direction now that a large part of our population is very concerned about the sovereignty of the family, the rights of the parents over their children, and that the road has diverted too far in the direction of allowing the system or government or professionals to decide what is best for children. In a sense, that is good because it does reaffirm the importance of the family, which is, of course, the basis of our society. On the other hand, it does indicate that we have, to some degree, moved back to the place where children are considered property of their parents.
Too much government intervention, too few social workers, too many re-abused children. For many, it was clear. Not only did the child welfare system have to change, but so did the laws governing child abuse. California was one of the first states to respond. Recently, state lawmakers passed Senate Bill 243, landmark legislation aimed at reducing the number of children brought into protective custody and shortening the time they spend in dependency court or foster care.
Something was needed to make sure that we screen out cases which can be handled without the court being involved. The new child abuse legislation narrows the definition of children who can become dependents of the court by limiting the types of problems that the court can examine. It specifically looks towards severe cases of physical abuse or of neglect. Likewise, it looks towards severe cases of emotional disturbance for the children.
Social workers who previously could use their own discretion to remove children from their homes must now follow tougher guidelines. They must find a child suffering from serious physical harm or be in substantial risk of serious injury. Critics say this means fewer children will be protected because their cases no longer qualify as abuse.
The idea is to only treat those most critically.
From getting involved in the family and from offering services to the family and from offering